Removing ADA risk, loss mitigation, cost coverage solution from AAAtraq. This slide takes you through the areas covered in the AAAtraq programme, including staff training, vendors, technical staff, policies, and the ACM. It includes details of the actions to take to remove risk. We're going to take you through some of the common questions that we get asked about AAAtraq. What about reporting the diagnostics? Something about testing against WCAG checks. This is very important, and you need to have a way not just to report, but to monitor, ensuring issues are prioritised and then fixed. Litigation is rife as organisations are reactionary to demands. AAAtraq is about taking control and removing the risks. Our software vendor has said that we don't need your service. They provide a report which says that we are okay. I'm sure they do. Just like the builder of my new house wants to sign off their own work. Too many vendors, service providers and consultants object to clients having our service. A good starting point is assessing the risk of your website yourself. At least you'll start with an independent view. Do you teach webmasters how to fix the issues detected? Firstly, executives must ensure that ADA awareness is organisation-wide. This is not just the web team's responsibility. It's important that webmasters have the skills to manage this. ADA litigation is not going away. Every organisation needs to be self-supporting. AAAtraq prioritises remedial actions in terms of maximum impact and minimum time required, highlights these actions against prioritised pages and monitors the corresponding correction. We use a plugin called AccessiBe. They suggested this would suffice for ADA compliance. There are many companies who make compliant promises. A web search of AccessiBe will get you sued may answer your question. Ask any provider who is committing to any level of compliance for an indemnity against litigation. Focus on removing the risk, not chasing compliance. There are no quick wins. Too many people are looking for technology that can provide the silver bullet, but in reality, what you need to aim for is training staff and ensuring accountability from vendors and those fixing the highlighted issues. More on plugins. Some plugins and overlays promise a one-time solution to web accessibility issues, but sadly, this just isn't enough to ensure that you are compliant with ADA regulations. While it would be great if it was as easy as simply installing a plugin or adding one line of code, unfortunately, this just isn't the case. Compliance needs to be managed on an ongoing basis, with the issues addressed at the root cause. Some plugins are so well known as being non-compliant that lawyers are deliberately seeking out websites that use them in their search for potential litigation targets. Will it also read PDFs and suggest fixes? AAAtraq will work through your website in a prioritised manner, understanding assets of all types over time. The starting point of PDF compliance is how they are created, and we provide an introduction at the appropriate stage. Basic fixes can be identified, but PDF remediation can be as unique as the content that they contain, with each one requiring a differing, unique fix. The key is to understand what assets, PDFs, etc., you have, their level of compliance, and have effective contracts with remediation providers. Can you please give me an example of an issue that might be detected? AAAtraq, first and foremost, is to be used to support those who manage risk, and then direct the technical staff and vendors to address key issues in a prioritised, time-effective manner. The key is the process around reducing ADA risk, of which compliance against standards is a measure. It is not about more and more reporting, getting into the details of the issues. It's about having accountability for those issues being addressed. One example is within our Check 3 Things. We look at alt text, form field labels, and link text. Accessibility statements. Does your program look at them? Do I need one? One of the steps in the program is to confirm the status of your accessibility statement. We also provide a draft for you to review and consider including on your website. Our system gives you suggestions and best practice, and our monitoring ensures a compliant accessibility statement is a priority. I didn't add my accessibility page in the first few tasks in AAAtraq. How do I go back and add it in? Yes, you can add your accessibility page at any time in the process. When logged into your AAAtraq account, you will see your initials in a circle in the top right corner. Select this and go to Your Account. From here, select Site Code in the menu. You'll be displayed with a screenshot of your site. To the right of this, you'll see Accessibility, and then to the right, there is an Edit button. Select this and enter your accessibility page. Does your scan cover all pages contained on the site, or do we have to submit a sitemap of all the pages needing to be scanned? AAAtraq is not a tool for the web team to use to scan the website. There are many tools which provide accessibility testing. However, the problem lies with actioning the issues raised in the reports. The AAAtraq program prioritises web content based on consumption and the corresponding corrective activity appropriately. The key is to removing risk is the accountability in actioning the corrections once in order to remove future failures, stop fixing the same problem, and holding to account those who commit to compliance. What's the extent to my exposure? Website non-compliance has become a reality in the US as organisations struggle to meet their legal obligations to limit online discrimination. Litigation is rife, and at the current rate of growth, every organisation could see a claim in the next 4 years. Every organisation faces a stark choice: comply or await litigation, and then comply. Website accessibility can be complicated and technical. AAAtraq was designed so that everyone can understand their risk of litigation. It's key to remember that the law itself is actually proving that your organisation can demonstrate reasonable adjustment to people living with disabilities, not just compliance to a standard. What are the laws and regulations? All organisations are bound under the Americans with Disabilities Act, the ADA, passed in 1990, which prohibits discrimination against those with disabilities by both businesses and public entities. Every organisation faces a stark choice: comply or await litigation, and then comply. In California, there is also the NRA Civil Rights Act, which applies to all businesses in California and prohibits them from engaging in unlawful discrimination against anybody within California's jurisdiction. There's also Section 504 of the Rehabilitation Act of 1973 and the Individuals with Disabilities Education Act, IDEA, which protects disabled individuals in the educational environment. Who is required to comply with accessibility regulations? Everyone. Taking the ADA, for example, it applies to both public entities and private businesses. Title II of the ADA applies to state and local governments and public entities such as municipal organisations and public school districts and colleges. Title III of the ADA applies to private businesses open to the public such as retail shops, hotels, restaurants and privately funded educational institutions. There's also the other pieces of federal and state legislation mentioned on the previous slide. What are the rules for public entities? Any public entity that receives federal funding is legally required to ensure that their website is compliant with accessibility regulations in accordance with Section 508 of the Rehabilitation Act of 1973. The same rules apply to anyone who does business with a federal agency. You can check any website for free at AAAtraq.com/check. It takes under 30 seconds and gives a clear indication of risk. Green is good, red is bad. The higher the inclusion score, the greater number of compliance failures and greater risk. Additional disclaimer. This is a sample of recent and most common questions that we have been asked during webinars. Products or services named are only used when they are specifically cited as part of an attendee question. Any and all trademarks and product rights remain with the respective companies. Responses are provided based on best available information at the time, none of which should be considered legal advice. Where matters of compliance are concerned, you should always seek independent advice.